That's how we wrap up the headlines. Time now to take a look at the lead. On Friday, the Labour Court granted the city of Tshwane a permanent interdict against striking employees in the metro. It comes after a month-long strikes by staff affiliated to the South African Municipal Workers Union after the city failed to follow through on a 5.4% wage increase deal. Now, this past week, the strikes, which were deemed unlawful, turned to chaos after the torching of city trucks, buses, and forcing essential service operations to be halted. Let's get some analysis on this deadlock now with the legal director at Strategy, Advocate Tertius Wessels. A very good morning to you. Thank you so much for your time. I mean, the city of Tshwane has been granted a permanent interdict against its striking employees. It's a Labour Court matter which the municipality started as far back as July to now interdict the actions of employees. What does Friday's ruling essentially mean?
Good morning, Paul, and good morning to the viewers. Yeah, so the interdict that was granted by the Labour Court on Friday simply serves as a final order that now permanently restrains the employees, or SAMU, from participating in the unprotected strike or any other conduct that is in contemplation or furtherance of that particular strike. Normally, when this process started in July, there would have been an application also on an urgent basis, but for an interim order. And that order then, at a later stage, gets made a final order, depending on the submissions that are put forward by the parties. And we can see, obviously, with the amount of violence, intimidation, and destruction that's being caused to public and private property, that this ultimately necessitated grounds for making that order final and binding.
The provision of services in the municipality has, as a result, been severely affected. This was something the judge had to obviously consider before granting this decision. What were the other considerations that had to be made?
Yeah, one has to understand that obviously every employee, in terms of the Constitution, does have a right to strike. However, where a strike does not comply with the provisions of the legislation, employers are entitled to interdict that conduct or behavior by employees. So in this particular instance, it's not only the simple fact that there has been intimidation, violence, or destruction of property that are factors to be considered, but it's also the fact that there's been failure to comply with prescribed steps as set out in the Labour Relations Act.
Employees having embarked on the strike since July to force the city to honour the last year of a 3-year wage agreement for 2023-24, how does this permanent decision affect workers' demands? What happens now?
In essence, employees or the workers are required to report back for duty and to resume their duties as per normal. It's very important for employees not to further engage in the unprotected strike or any other conduct in contemplation or furtherance of the strike. It's important that the workers understand that by failing to adhere to this court order, they are putting themselves in a position where their employment could likely be terminated. We've already seen that the city of Tshwane has embarked upon a process of dismissing hundreds of employees' employment, and one wants to avoid those situations. It's not only in their best interest, but also in the interest of their families. There is a process, and we have to understand this, that whilst there was an agreement that there would be wage increases implemented over a 3-year period, there is also a process in place for the city of Tshwane to ask for an exemption from implementing those wage increases. Now, they've already embarked upon that process, and we've seen that the Bargaining Council has ruled that there is provision in the budget for these increases to be implemented. So there's already, the process itself is working out in employees' favor, and there's no need for this unnecessary conduct or behavior to get their demands met. Yes, the city of Tshwane is taking that decision by the Bargaining Council on appeal, but allow that process to unfold, because ultimately it can only result in further job losses, disruption of service delivery, and potentially that those that don't honour the court judgment can be held accountable for compensation for any losses that result.
Yeah. I mean, while it's important to note that the court restricts employees from participating in the unlawful strike action and performing any acts in continuance, what sort of legal recourse is there for the workers when it comes to the municipality agreeing to something and then seemingly backtracking?
Well, the employees and the trade unions have the ability to either enforce or try approach the court to enforce the agreement. But like I've mentioned, the agreement that was entered into at the time also makes provision for an exemption process. Now, normally these collective agreements are struck over a period of 3 years and in certain cases 5 years. And we know that circumstances change year on year. So when an employer feels that they cannot or no longer have the means to implement what was agreed upon, they have the option to apply for exemption. And the workers and the trade unions can oppose that application, which in this case they have done. And the bargaining council has then ruled in the workers or the trade union's favour, if one wants to look at it that way. So yes, there is processes and means in place to handle these kind of situations, but resorting to unlawful conduct or behavior is not going to serve anyone in the immediate.
Yeah, absolutely. Thank you very much for that. Legal Director at Strategy Labour Solutions, Advocate Tertius Wessels.